Muneeza, are you good?
I am good.
Okay.
Assalamu alaikum, everyone.
Assalamualaikum. Welcome, everyone, and thank you for joining us. My name is Zoya. I'm an associate at Levitt LLP and a board of director of MLA. Today, I'm honored to have Muneeza Sheikh with me, partner at Levitt LLP, who regularly, I'm sure you've seen her appearing in the media, discussing labor and employment matters. As you can see, we're being responsible and socially distancing ourselves and doing it from our respective spaces. So we've had a number of questions coming in from both employers and employees about what to do in sort of these challenging times. People are not only concerned about their health, but also their employment and businesses at this time. And we know it's a rapidly evolving situation. So Muneeza and I will do our best to answer your questions as they come in. We ask that you type your questions in the chat box on the side, and we'll go through them. We'll also talk a little bit about some of the legislative changes that were recently announced by the respective governments. So we'll start off with some commonly asked questions, and hopefully that answers many questions, and then we'll go into what's specific in the chat box. Go ahead, Nancy.
Wait, Zoya, before you even start, so just to add, so thank you so much, everyone, for making the time. I know it's really a stressful time right now with everyone feeling like they're quite very much in a precarious situation. So we feel that. So thank you for finding the time to sit with us for a little while. So just adding a little bit onto some of the points that Zoya has made. I mean, the purpose of this really is for you folks to drive the discussion, any questions that you might have, pretty similar to the format I've been running on CBC, where people just call in with their questions and we do our best to answer. As Zoya mentioned, I mean, unfortunately, with respect to the COVID virus, our advice sometimes is changing, not just day by day, but it could change within a few hours depending on what may come down the pipeline from a government perspective, or any public health warnings that might be issued. So take all of it with a grain of salt and understand that by the time we're done this webinar, maybe some of what we've outlined to you becomes obsolete because, or not even valid anymore because of some announcement that we're waiting for from the provincial government today. I'll also say that the purpose, as I understand it, in terms of who's joining us today, some of it is just going to be general interest for yourself, but some of it, as I understand it, is also for the non-employment lawyers in the group. Maybe some of you are corporate lawyers, and with some of your corporate clients, instead of going to see an employment lawyer, they may ask you some employment-related questions. I certainly know that I've been in that situation where I have corporations that are my employment clients, and they ask me questions which I then need to divert. So I'm hoping, at least on some level, we're able to assist in that regard. And of course, following the workshop, you can either reach out to myself or Zoya.
Perfect. Thank you. Okay, let's dive right in. So I'm going to start off with the commonly asked questions, and then I'm going to jump into, we've already gotten a number of questions in our chat box. So, Muneeza, one of the most common questions we've been getting, as I'm sure you've gotten as well on the shows, is does an employee have a right to stay home and get paid if they have to self-quarantine themselves, either because they've been traveling or been exposed to someone with COVID-19? What are the parameters around that?
So at this point, Zoya, you'd be really hard pressed to find any employer who would say to you that despite the fact that you may have been exposed to somebody who may have been exposed to somebody who had the virus, or despite the fact that you were traveling, not even now from one of the hot spots, but really from anywhere, you'd be hard pressed to find any employer at this point who would say, no, you do have to come into work. Obviously, we do understand that there are some essential services. And in those circumstances where your employer has provided you with the necessary tools to protect yourself, and I'm really talking about healthcare providers largely, then you do have an obligation to come in. But for everybody else, for the most part, if you can genuinely, outline to your employer that in fact you have returned from travel, or you may have been exposed, then ultimately you absolutely have the right to insist on staying home. Now, I will add another interesting piece here because it comes to mind, and it's come up with some of my employer clients in the last couple of days, where I've had clients come to me and say, Muneeza, I think X or Y is lying. So, we've got everything set up from a distancing perspective in the workplace. We're being mindful of the fact that things need to be cleaned a little bit more vigorously. And, we feel quite comfortable with the necessary precaution that we put up in the workplace. But we, there's this employee, and we feel that, they're lying. And I can give you an example right now. I had a client a very large uniform company in Canada, who took the position that they had an employee that came in wearing a mask, saying that he thought he had the virus because he was exposed. They then sent him home, and he then came into work the very next day. Ultimately, what they sent him home saying that we need a little bit of time to figure out, if we can turn your position into a remote position. It was largely machinery work, and what we're going to have to get back to essentially is what they said. So once it became clear to him that he may not necessarily be able to work from home, he actually showed up the next day and said, "Oh well, I just said that. I just was feeling not safe, and I was a little bit worried, so I thought it might be best to say that I was exposed." And as harsh as this might sound, hopefully not harsh to my non-employment lawyers in the group, or to my employment lawyers in the group, I should say, my recommendation was fire him for cause. I mean, what we're dealing with is so significant and so serious in the workplace that for someone to come in and purport to have the virus, and potentially expose everyone, that causes what I would deem to be an irreparable damage to the employment relationship, such that all trust goes out the window. So we did do an investigation meeting, and we did terminate him for cause today.
Okay. And you actually raised a really good point about workplace safety, which I'm going to get back to in just a second. So on that note, so if the employee has not been exposed, hasn't been traveling, or symptomatic, but wants to work remotely because they're trying to social distance themselves, given some of the concerns that have been raised, what are the parameters around that? And do they have to be paid at this time?
Okay, great question. And I think it's a question that was super relevant a couple of days ago, and certainly about a week ago. It's becoming less relevant now because now everyone's being told to stay home. But I think it'll resurrect itself in terms of relevancy in a few weeks when someone tells us that the bulk of the threat has ceased, and some of us can start trickling back to work. And then essentially you will have those employees who might say that I just don't feel comfortable coming in. So, from a legal standpoint, your employer has an obligation to accommodate you. The employer does not have an obligation to accommodate. If you're essentially just worried, what I guess my point is that if you have a concern, it needs to be linked to something viable. So, by way of an example, about a week or a week and a half ago, or even 2 weeks ago, when we weren't hearing as much about the spike of cases in Ontario, public health officials and the government were largely saying that, okay, if you've been traveling to this area, you should consider self isolation, self quarantine. But we were largely still feeling safe, and it was largely still up to the employers to determine whether or not they considered a work from home appropriate. There were some of my clients who were reaching out to me saying, look, we've got employees who are saying they don't feel comfortable coming into work. And like I said, this will resurrect itself when we're on the other side of this. And my legal advice to them is, if you have put the necessary precaution in place, and if it is from a government perspective, from a public policy perspective, no longer an imminent threat, then you have no obligation to accommodate a person not wanting to come into work. So right now, absolutely. But once this trickles down a bit, you have no obligation to allow them to stay at home. And certainly, if you have no obligation to allow them to stay at home, then you don't have to pay them.
Okay.
Did I answer all of that, Zoya?
I believe so. So I'm going to jump into some of the questions because we're getting quite a bit of them. So one
Okay.
of the questions is, I am an associate dentist, so self-employed, wondering if I qualify for EI based on the new changes from the federal government.
So those changes from the federal government have been implemented to make it as easy as possible for everyone. So I'm assuming, pardon me, if you're an associate dentist, then presumably that would trigger some sort of self-employment. And in those circumstances, there is funding that the federal government has put in place. But when we're talking about EI and self-employment, if in fact you are being paid as a consultant, or if you are being paid as an IC or even a dependent contractor, then technically you don't have access to EI. I think there could be some other funding that's coming down the pipeline, but if you're technically an employee, the only latitude that's been given from a Service Canada EI perspective is a decrease in terms of insurable hours, There's no longer any obligation to provide a medical note, so not such stringent medical documentation. And most importantly, there's two pots of funding. So there would be one pot of funding as far as sick benefits go if you're actually self quarantined, but if you extend that entire 15-week period and then ultimately get sick after that, then from an EI perspective, you would be able to apply again. If you're purely self-employed, then as it stands, EI is not your best, unfortunately not an option that's available for you right now.
Okay, and just to add to what you were saying about the pots, I think the federal government had just introduced that emergency care benefit. So if you're sick, you're quarantined, taking care of a family member who may be, and you don't qualify for regular EI sick benefits, you're eligible to, I think it was $900 every 2 weeks for up to 15 weeks. So that also extends to the self-employed workers as well.
And dependent contractors as well.
Yes. Okay, moving on to the next question. Um, Okay, these are some good questions. So I'm gonna just group them all together. So essentially what many of these questions revolve around is if you're an employer at this time, there's a lot of the challenging times for businesses, can they start temporarily laying off employees who
Ugh.
they can't work from home or they don't have work for them?
Such a good question. Okay. The layoff question. So the view generally seems to be, particularly with smaller employers, is that you have the right to lay off. And from an employer's perspective, there's very clear cut layoff provisions outlined in the provincial legislation. So why wouldn't you assume that because it's in the legislation, you can do it? Sadly, the answer to that is, can you do a layoff? Maybe. So, unless you have a very clear term delineated in an employment contract that is signed by your employees, which expressly gives you the right to lay off your employees, if you do lay them off, essentially it's a constructive dismissal. So let me tell you what I mean by that. So let's assume for a moment that I'm working for Zoya. And Zoya's like, okay, I essentially can't afford to sever Muneeza out as far as severance or termination pay might go, and B, I'm just going to go ahead and lay her off because there simply isn't any work for her, and hopefully by the time the layoff period is done, operationally I'll be able to call her back, or Muneeza finds another job at the end of the layoff period, and she simply isn't my problem anymore. I've heard people say that Muneeza isn't my problem anymore, but nonetheless, in those circumstances, if Zoya is under the assumption that she can simply lay me off without having a provision that would be clearly outlined either in a contract that was provided to me at the time that I was hired, or a change or an amendment in an employment contract at some point later in my employment when I was given a raise or given a bonus or a promotion, technically she can't lay me off. So assuming Zoya does lay me off, absent that clear provision in a contract that says, look, I have the right to lay you off, she can't. And if she did come to me with a layoff notice, I would turn around and say that, look, nothing gives you the right to lay me off, notwithstanding the fact that it is in the legislation. You've got the legislative right to lay me off, but not the common law right. And so if you want to lay me off, as far as I'm concerned, it's the same as a termination, which would deem it to be a constructive dismissal, which means that you would have to pay. Zoya would essentially have to pay. Now, I will say that the advice that I'm giving my employers at this time, because I'm sure the people who are watching can appreciate, especially since Zoya says so many of the questions circulate around this concept of a layoff. Many of them are coming to me saying, Muneeza, we have no such provision. We've got people who have been here not just for 5 or 6 years, but we've got people who've been here for 10 years, 15 years. We obviously have no employment agreement that would allow us to lay them off. So what is it that we do? At some point, what you have to understand is you can go ahead and implement the layoff, understand that you might be exposed from a liability perspective, meaning implement the layoff, understanding that there isn't anything that the common law that allows you to do that, and appreciate by the time the person retains counsel, assuming they don't find another job, and by the time a lawyer circles back to you with a letter, outlining demands that they might have, hopefully this issue around the COVID virus would be behind us, and most companies hopefully would have been able to resurrect themselves from an operational perspective. So it's strategy, and unfortunately, it's as Zoya knows, we work together. It's a strategy that a lot of our employers who have seen a significant decline not only to their bottom line, but in some cases, there isn't a lot of hope for their ability to climb out of this whole period.
Right, especially the smaller businesses, particularly in this situation. Just to add to that, there might also be a situation where employees, because right now finding alternate employment is going to be very difficult, they may just really want
Right.
to at this time.
Right. And so Zoya's right. Outside of this period, one of the huge benefits with anyone who wants to resurrect a claim saying that a layoff is actually a constructive dismissal is by the time they go through the whole horse and pony show, especially if they're on the younger side, they usually mitigate their losses, and then you can kind of turn around and say, well, what are you suing me for anyways? But that isn't a luxury that's available to employers right now, given the current crisis.
Sure. On a similar note, someone is on vacation and they've been probably along you probably already answered this, but they're on vacation and they want to know if they've been told that there may be a layoff coming. What can they do?
So, I mean, if you're told that there's a layoff coming, there isn't much you can do outside of wait for when the layoff actually comes down the pipeline. Ultimately, if you're on vacation and you're returning, you'll probably be, not even probably, you would be quarantined, and then your employer would be paying you during that time. And then when the layoff comes down the pipeline, you would have to make a determination in line with what I've outlined right now, which is, does the employer have the right to lay you off? So shuffle, look back at your employment agreement that you would have signed either at the time that you were hired, or any new employment agreement that you would have received after you started employment. And if there is no layoff provision in there, then technically your employer doesn't have the right to lay you off, and it would be a constructive dismissal. Now, I will say, certainly, I'm not encouraging anyone to, sort of aggressively go with that strategy, only because the job market, unfortunately, is so depleted right now. So sometimes it might be better to deal with the unfortunate financial consequences of being on even an unauthorized layoff in hopes that you actually get called back to work.
Sure. That's an interesting one. This is sort of I guess you could say, misconception that's often held about these layoffs. It says a temporary layoff can last 13 weeks and they're considered terminated. So, we can talk about that a little bit.
Yeah. So basically, essentially, what happens is if your employer doesn't call you back to work before the expiry of your temporary pardon me, if your employer does not call you back to work prior to the expiry of your layoff period, then essentially it's deemed to be a termination and you should be paid your severance. Now, the interesting thing there is if ultimately by the end of your layoff period, you found another job and replaced your income, then you wouldn't be entitled to the common law portion of your severance. You would be only entitled to the statutory portion. So I'll tell you what I mean by that. So if, for instance, I've been working for Zoya for 10 years and I'm owed 8 weeks of termination pay, but I'm earning about 100,000. So I know from an ESA perspective, there's no severance payable in this case, let's assume. So I know from a termination pay perspective, I'm owed 8 weeks, but I know, given my age, which I'm not going to disclose, given my tenure of 10 years and my compensation of say $100,000, I know that I'm actually owed 10 months of pay. So I'm laid off. And at the end of the layoff period, Zoya advises me that, operationally she's largely depleted. There's no job for me. But I found another job, then I wouldn't be able to sue, assuming that I'm at the same compensation level or close to, I wouldn't be able to sue Zoya for the 10-month common law notice period. It would only be the statutory entitlement that I have, which in Canada means that you get that portion regardless of whether or not you've mitigated your losses as far as finding alternative employment.
Okay, and just to add to what you've been saying, most of this layoff applies to non-unionized employees
Yes.
for unionized employees. And in terms of 13 weeks itself, uh, that I think in employment standards under the Ontario Employment Standards Act is 13 weeks. If no benefits are provided, you're considered terminated. 35 weeks if benefits are provided, you're considered terminated.
And the last piece, just tying into what Zoya said on the union piece. So if you are a unionized employee, then ultimately, your layoff provisions are outlined in your collective agreement and are 99.9% based on seniority.
Perfect. So it's the next question is I'm a full-time employee. I returned home. Now that I have to self-quarantine for 14 days for safety, even though I haven't been exposed to the virus, can my employer still ask me to use my vacation for these 14 days? I'm ready to work from home, but they have been able to sign it.
So I think because there's a direction from the government now for everyone who's traveled outside to self quarantine, it would be unreasonable. So I mean, it's a government direction. It's not something that you're doing by choice, especially if you're not symptomatic. But in these circumstances, it would be highly unreasonable and legally untoward for your employer to insist that you use your vacation bank, and instead it should be 2 weeks paid.
Okay. And on a similar note, what about the family members of the person who just returned? Now, the family members also have to self-isolate for 15 days. Can they be penalized by their employer? And do they need to apply for EI?
So we've just seen some provincial legislation that came down the pipeline today, actually, either it was today or yesterday, Zoya, I think, which basically outlines that if you're having to stay home because you have a family member, and that definition of family member, I think we've got it here somewhere, or so I think we can look that up. It was in the notes that we had prepared. It is quite a broad definition. So certainly, if you're having to self isolate or self quarantine because one of your family members has been exposed under the Employment Standards Act, that has now been that is a very expansive definition in terms of who that might be. But I will say to the people on this call that it's my view, at least, that those changes that we just saw come down the pipeline today, as far as it relates to the ESA, I think they're largely for optics to clearly demonstrate to the public that the provincial government is doing something. Because I can tell you, as an employment lawyer, as a human rights lawyer, those protections already existed under the Human Rights Code, admittedly with not such strong case law to support what the definition of a family member might be. But I think, and so what I'll tell you what I mean by that. So what I mean by that is, if we didn't see these legislative changes from the Employment Standards Act, and it was a situation where Zoya and I were related, and Zoya had been exposed to, Zoya was traveling or exposed to somebody with the virus, then under our current human rights legislation, I would be allowed to say, look, I need to stay home because a family member of mine has been exposed. But that isn't as crystal clear to the public in terms of layman's terms. So I think the purpose of the legislative changes we saw today with the Employment Standards Act is to spell that out a little bit more explicitly. And if you look at the preamble to those changes, it does outline that these are protections that are already offered under the human rights legislation.
Great, thank you. This next question is about, I think it's an EI question. It says, what is the mechanism for small companies, not-for-profits, to access the 10% wage subsidy announced by the federal government? This may be referring to the work share program.
So, Zoya, I'm not entirely familiar with that one. Do you want to answer that one?
Sure.
Or if it's a question we don't, we can always take it back and pull back with an answer shortly after the webinar.
Okay. I mean, the question's not completely clear, but if it does refer to the work share program, the work share program basically allows eligible employers to avoid some of the layoff situations when there's been a temporary reduction in business. So if work has been reduced by at least 10%, the employer can apply for a work share program, and then the employee can apply for EI benefits to help subsidize some of that reduction in work. The federal government basically expanded how long the program can last for. Before it used to be 6 to 38 weeks. Now it's
And now significantly, right.
yeah, if that's what the question is. The next question is, I'm currently on maternity leave and my leave will finish in May of 2020. I had a meeting with my employer last week and he stated that I might not have a job to come back to due to COVID-19 and the company is losing clients. Do I have access to any sort of benefit?
So technically, and it's a good question because it comes up quite often, just to talk a little bit around what the general obligations are when you're completing a mat leave. So again, under provincial legislation, your employer does have an obligation to put you back to work if your job exists. So what I would probably say to that employee is, just because your employer has said to you that your job is not going to be available because of COVID-19, I wouldn't necessarily take that statement at face value. I would encourage the employee to ask a few questions and say, well, ultimately, to what extent has the organization been affected operationally, and what does the employer mean by not having access? But if ultimately the termination is strictly related to COVID-19 specifically, it is my view, based on some additional changes that we would expect to see coming down the pipeline, specifically for people on parental leave or maternity leave, that you might be able to apply for EI.
Great. So the next question is about a unionized employee who has been on sick leave.
So forgive me, so I missed that last part. Say that again.
It's a unionized employee who has been on sick leave and now would like to return to work to protect their sick leave benefit with doctor's calling. What are the employer's obligations when it comes to the duty to accommodate?
Okay, so the employer, as I understand it, so the employee is on sick leave.
Yes.
Okay, and now wants to return to work and is able to return to work.
Yeah. No, yes, with the doctor's clearance.
Okay, so the interesting thing about unionized employees is if you have any sort of grievance or issue with your employer, you are bound by the four corners of your collective agreement. So, unlike the rest of us, making a lot of assumptions in terms of who's listening in on this call, assuming the rest of us are non unionized employees, depending on the nature of the claim, we could go to the Ministry of Labor, we could file an occupational health and safety complaint, we could file a human rights complaint, or we could go to the regular courts. If you are unionized, the only, and I say that like I use the term only in a soft manner because there are many employers that will, or many employment lawyers, I should tell you, who will tell unionized employees that they technically can file a human rights complaint. But even if you file a human rights complaint, you have to demonstrate pretty clearly to the tribunal that you did make best efforts to file a grievance first, because grievance arbitrators have the jurisdiction to hear any sort of human rights issues. So if you are on a sick leave and ultimately you are ready to return to work, then you should essentially be able to, probably maybe through your chief steward, advise your employer that I'm ready to return. I don't know the nature of being off on the sick leave, if it was multiple medical notes, which sometimes happens, and maybe because of the type of work that it might be, in some narrow circumstances, your employer may be able to say to you that, look, just because you're saying that you're ready to come back does not mean that we're ready to take you back without either an independent medical examination, which the employer would then pay for, although they are quite invasive and it's an uphill battle. So if you're an employer, you want to be very cautious before you start suggesting to your employees that you want to do an IME, or your employer may ask you for more comprehensive medical documentation. So if it was a matter of, hey, I broke my arm and I work on a machine and I can't work for 2 weeks or 3 weeks, here's my medical note. There's no reason, once your cast is off, and I know I'm being overly simplistic here, that your employer shouldn't put you back to work. But maybe, like with a lot of my clients, it's an ongoing sick leave where you're supposed to return to work and then you get another medical document, which has happened. With some of my clients, it happens to the extent that it ends up turning into a frustration of contract. In those circumstances, don't be surprised if your employer through the union says that, look, we either want an independent medical examination given the type of work that you do to ensure that you're actually well enough to return to work, or we're not satisfied with what you've given us as far as a doctor's note goes, and here are some questions where we're not asking about the diagnosis, but we're asking about your prognosis and your ability to work full time. So whether or not your employer asks the question depends largely on the reason you were off, how many times you extended your sick leave, and what type of work you do. And remember, if there's any sort of issue and your employer does anything legally untoward, 9 out of 10 times it is your union that has an obligation to represent you in that regard. And so you can't necessarily just go up to the Human Rights Tribunal or sue them. You would have to go through your union and they would file a grievance on your behalf. And a grievance arbitrator has the jurisdiction to hear all complaints.
Perfect. And the next question is, can a layoff or termination happen digitally, or does it have to be in person?
Say that again.
Does a layoff or termination have to be does it have to be in person, or can it happen digitally or electronically?
Well, I would say now it can happen electronically, given the fact that so many of us are working from home, if we're able to work from home. So, but even outside of this whole issue around COVID-19, there's nothing necessarily legally improper or untoward about receiving a letter in the mail or something electronically saying the employer is implementing their right to, or pardon me, triggering their right to implement a layoff.
Okay. A lot more of the layoff questions you've answered.
So if
Uh,
there's a lot of the same questions, Zoya, maybe what we can do is bunch those ones together and respond to people afterwards, so we can kind of go through the different categories. Because I know we've got, we're halfway through already, but we'll try to get to everyone, try to answer everything. But if there's something unique that stands out, and inshallah are committed to try to circle back to others with other questions that they might have. of course.
Someone has asked about for access to the recording. Yes, the recording will be posted and we'll be sharing the recording afterwards. Okay, at what point can we disagree to a layoff?
So it's not a disagreement. So it's a legal principle, right? God, everyone loves the layoffs today, but no, I get it. I completely understand why. So it's not a matter of you as an employee saying that I'm disagreeing with you laying me off. You essentially would say that either you have the legal right to lay me off or you don't have the legal right to lay me off. If again you've signed an employment agreement, and I'm not necessarily saying that you should make any assumptions around its enforceability. If you have questions around a layoff term, even what appears to be on its face an express layoff term in an employment agreement, take it to an employment lawyer and we can certainly walk you through whether it's enforceable or not. So it wouldn't be I agree or disagree with my layoff. It would be, do you have the right to lay me off or you don't have the right to lay me off? So if I take issue with express language in an employment contract, or if there is no express language in any employment contract and therefore there's no common law right to lay off, then it would again go back to that earlier principle that we discussed around a constructive dismissal. But if at the end of the day you've signed an agreement which clearly and unequivocally gives your employer the right to lay you off, if you disagree with it, it doesn't really make a difference. If the employer has a legal right to do it, they can do it.
Okay. And now we have some health and safety type questions. So, what steps does an employer have to take to ensure that the workplace is safe during these times? And I guess it would range depending on the industry.
Right. So there is always, from a provincial standpoint, there is always a legal occupational health and safety obligation to ensure that your employees are working in a safe and healthy work environment. And again, if this is another one of those questions, which was out, before we went into this whole lockdown work from home mode, which was very relevant about a week ago. And I can assure anybody who's listening in that it will become relevant again, once we're on the other side of this COVID-19 issue. But when your employer has a right to ensure that you're safe in the work environment, that could ensure that obligation extends to ensuring that you're not working in a toxic work environment. That obligation extends to making sure that the machines that you're working on are safe. And certainly that extends to ensuring that you're not unfairly or unreasonably exposed to risk as far as it relates to a virus like this. So I had a case not too long ago. In fact, when I was on the CBC last week, where somebody had called in, and she was essentially saying, now I remember, that there was somebody in her workplace, and it was actually, I believe, either management or the owner of the company, who, in her view, had very clear symptoms of either a flu. And unfortunately, the symptoms of the flu and, the COVID virus, they seem to be very much in line. And he was also very vocal in the workplace about saying that this whole issue around COVID-19 had been blown out of proportion. And so his commentary around the virus coupled with his symptoms led her to say that, look, I don't feel comfortable saying anything, but I don't feel safe being exposed to this guy. And ultimately, I'm too afraid to say anything because I'm actually concerned that I might lose my job. So in those circumstances, you can always file an anonymous complaint with the Employment Standards Branch, who will, I don't know what the reaction time is right now, but they would send a Ministry of Labor officer to go and investigate. But yes, an employer has an obligation to keep you safe and healthy in the workplace, and that extends to ensuring they are safe and healthy and the people they are allowing in the workplace are safe and healthy. Because keep in mind, once this imminent issue around COVID-19 is behind us, in the sense that people are no longer being mandated by the government to work from home, there could still be times where everybody else is back at work, but maybe it's unsafe for me to be back at work because I recently was exposed to somebody who came back from one of the hotspots, or I was recently exposed to somebody who recently, had a member who had a family member who had the virus quite some time ago. There could be a multitude of reasons. So we're going to see a lot of these sort of questions resurrecting themselves again.
Okay. So the next question is about childcare because of the closure of childcare facilities.
Yes.
People are sort of being forced to work from home or to take care of their children. Should this time be paid out as it is out of the employee's control? If not, will employees be compensated for those days?
So as it stands, you will not lose your job because you have to stay home and take care of your kids. I myself am in a similar situation. I've got an 11-year-old and a 7-year-old, and I have a caregiver. Very fortunate to have a great caregiver who helps us, but she's in her 60s, and we have mentally prepared ourselves. She's already asked to go down to 3 hours a week because she just feels like she needs some rest. And we've mentally prepared ourselves that at some point she may very well say to us that, look, I feel safer being at home right now. And so, in those circumstances, your employer could never turn around and say to you that, oh, your 2 week period is done. And notwithstanding the fact that your kids are at home and you have no childcare, you can't afford childcare, you have to come back to work. You have the job protected, your job is protected, but they would not have to pay you. So, after you bank out your EI benefits, maybe you could tap into a couple of sick days. Maybe your workplace has a couple of personal days, and maybe you could start tapping into your vacation days to have it paid as long as possible. But although you are legally entitled to job security, you are not entitled to payment.
Okay. So this is one about being self-employed. Because I'm interested to know what sort of measures are being taken to make me self-employed. I own a restaurant, don't have any staff, but still have to pay rent and overhead. Do you have any info on this? Is EI applicable to business owners?
Okay, so EI is definitely not applicable to business owners, but I would encourage this individual who's asking the question because it is such an important question and it really is a critical one. And, my heart really does go out to a lot of these small businesses, whether they're restaurants who are still, responsible for these very significant overhead costs, or like a client who reached out to me recently who was running a small daycare out of her home, and was financially responsible for like a special needs adult daughter and her son. So what you need to do is stay on top of grants and funding that are coming down the pipeline from both the provincial and the federal government. So, can you apply for EI? No. Is this really an employment related issue where you can get an employment lawyer to assist? But what I would do is stay on top of going to the provincial website, to the federal website, because they are cobbling together a significant amount of money to provide some sort of support. Certainly not to supplement the entire amounts that you would have earned, especially where there's high profitability, but there are a number of grants and banks being put together, and I would encourage you to apply. And normally, in my experience, some of these federal grants and provincial grants are quite difficult in terms of actually going through the process of applying for them. But I understand that they made it quite simple given the current crisis. Pardon me.
Right, and I think they did introduce a small business subsidy,
Yes.
some temporary wage subsidies for 3 months, but in this case, the person's saying they don't have any employees, so they can look into it and see what else might be out there. But then I agree with that. I need to follow along because there might be a lot more coming along. Um, just going through a lot of layoff questions.
More layoff? And
Yeah.
anything different on layoff?
No, not really. Okay, are people who are currently unemployed and actively seeking work and applying postings eligible for EI? Recently
No,
resigned from my position, terminated a contract for permanent casual position, and have been seeking new employment in Ontario since March.
I missed the last part. Zoya, go ahead.
I recently resigned from my position and have been seeking new employment in Ontario since March.
Okay, so March is pretty recent, and if you applied for EI, I mean, the problem you have is technically you're only entitled to employment insurance if you've been fired, and even in a scenario where you are fired and you're fired for cause, as Zoya knows and as other employment lawyers know, you wouldn't be entitled to EI in those circumstances either, because from a Service Canada perspective, well, if you did something bad, then even though this is an EI fund that you've been contributing to, you're actually not entitled to it. And oftentimes, I will tell my clients, because I have a plaintiff practice and an employer practice, who say to me, well, Muneeza, I've been terminated for cause. I say, even though the code that is on your ROE does not entitle you to EI, go ahead and apply anyways. And once you're contacted by an officer from Service Canada, explain that you're challenging the cause allegations. And more often than not, as Zoya knows, they are ultimately entitled to collect DI in those circumstances. This is new. I do not know of any scenario where an employee has resigned from employment and has been able to collect EI, except for one narrow exception. And that narrow exception is where the resignation is not a real resignation. So let me tell you what I mean by that. So what I mean by that is I might be resigning from my workplace because the work environment has become, so toxic, or maybe it might be one of those scenarios where I was being laid off, but ultimately I took the position that it wasn't a real layoff because there was nothing in my employment agreement that allowed the employer to do that. So in those circumstances, well, I technically may have resigned and my ROE might say resignation. It's not really a resignation. Instead, it might be, I didn't resign. I had to go because I had to go because of all these terrible things that were happening in the workplace. And I'm now dealing with that. And here's my proof that my lawyer has sent a letter. Here's a statement of claim that I filed. And in those circumstances, you can certainly try to make the pitch and apply for EI. If
Okay.
it's a straight, true resignation that you're not entitled.
Okay, and can an employer force an employee, especially administrative staff, to continue to come in?
Again, it's all a matter of perspective in terms of where we are, and as everyone knows, this is changing on a day-to-day basis. So when we say forced to come in, you have to look at the context. So I would say a week ago, or 8 days ago, 9 days ago, that if you as admin staff were being told that you needed to attend in the workplace and you had not been traveling out of the country, or you had not been traveling to one of the hot spots, or there was no reason to believe that you had been exposed to anybody with the virus, then there's nothing improper about your employer saying that you have to come into work. In the current climate, where there is an encouragement to work from home, if your employer, whether you're admin staff or not, is forcing you to come in those circumstances, if the employer says if you don't come in, you get fired, certainly you would have a great wrongful termination case. But again, take that advice as applicable for the now, because again, I've said it over and over again, that at some point we're going to get to the other side of this, and your employer is going to say, the workplace is safe for all of these reasons, and you're going to say it isn't for these two reasons. And then we're going to get into a little bit of a dogfight as to whether or not those employees can be forced back to work. And in those circumstances, I would say don't assume that you can't be told to come into work just because you're uncomfortable. We're all uncomfortable right
Okay, and again, a number
now.
of
Sorry,
layoffs.
you want to take the next question, Zoya?
Yeah, well, I mean that you pretty much answered it. The next question is basically, what about a layoff where you are 100% going to call the employee back?
So if you're laying the person off and you know that you're 100% going to be calling the employee off, then keep in mind the same legal principle applies, that if there is no express provision in the employment agreement which gives you the right to lay the person off, you might do it. You might know that at the end of the layoff period they'll be called back. But keep in mind, the employer may turn around and say, there isn't an express provision that allows you to to lay me off. So you've really just fired me. This is no different than a constructive dismissal. Now pay me my severance. By the time the employee sadly retains somebody, the lawyer sends you a letter, somebody files a statement of claim, the list goes on and on. You might be at the end of the layoff period anyways, and the employee in question may have found an alternative employment, in which case, even if they do have a strong and viable case, you're only on the hook for the statutory portion.
Great. Okay, I think we've
Sorry,
answered.
my email is jumping out at me too. I have people who are watching emailing me too. That's cheating, guys.
Yeah. So I think we've answered most of the questions in the chat box. Most of them are sort of repeating, and we can always go back to the rest of the video. We're going to post the video. We'll share the video. Everyone can go back and watch it. It's mostly again for layoffs. So we know it's a big concern. If you have individual questions, obviously you can reach out to us. Muneeza, do you want to talk a little bit about just the general government changes so far, legislative changes?
You know what, Zoya, because I've been chatting so much, I'll let you go through them and you've got them right in front of you, and then I'll pipe in if I need to.
Perfect. Sounds good. Okay, so we know on the federal level, there's been a number of changes to, for example, EI. They've removed the 1-week waiting period if you do qualify for EI-sick benefits. They no longer require a medical certificate for the COVID situation. We've talked a little bit about the emergency care benefits. So if you're sick, you're quarantined, or taking care of a family member who might be, and you don't qualify for EI sick, you're eligible for about $900 for every 2 weeks, up to 15. And that also extends, like we talked about, to the self-employed workers as well. We talked a little bit about the care program and sort of related to employment, not so much, but they've extended the tax filing deadline for June 1st and as well as the payments as well. On the provincial level, yesterday they announced the Employment Standards Amendment Act. Infectious Disease Emergencies 2020. It provides job protection for employees who are in isolation or quarantine due to the COVID-19 virus, and for those who need to be away to take care of the children or because of school or daycare closures. So it kind of speaks to some of the questions that came up earlier. And these measures are actually retroactive to January 25th, 2020. So that was when the first confirmed case of COVID-19 was confirmed in Ontario.
The only thing I'll add there is, again, I think this was more of an optics move, because these are protections that, as far as I'm concerned, already existed under our current human rights legislation. But I don't think it's a bad thing necessarily to like solidify that, especially if you have an employer who may not have clearly understood the obligations because they're not as explicitly outlined in the human rights legislation, and is more explicitly outlined in the ESA. So not a bad thing, but these are not entirely new novel protections.
Right. Someone just asked if they can qualify for the emergency care benefit along with EI benefits. My understanding is that, and things, I don't know if you understand differently, but it's basically if you don't qualify for EI sick benefits, then you get the emergency
Absolutely.
benefit.
Absolutely.
Okay.
The only thing just one thing to add. I think if you guys have some feedback, if you'd be kind enough to send it to Zoya, only because I think this is the sad gift that's going to keep giving. So I think, we're going to see there's going to be an influx of a bunch of new questions once we're on the other end of that, inshallah, soon. And then we'd love to host another one if you guys thought it was of any value.
I think those are all the questions. So thank you everyone for joining us. We hope this was informative and educational, and hopefully helpful to everyone. Thank you to the rest of the CMLA for organizing all of this. We know it's sort of a very uncertain time, and for many. So please feel free to reach out to us, contact myself, Muneeza, and if you want to contact the CMLA, if you're looking for assistance, we can definitely connect you with our network of lawyers, as well as through the Muslim Legal Clinic that we have called the Muslim Legal Support Services. So feel free to contact at contactcmla@gmail.com, and we'll go ahead and add that into there. Thank you so much, everyone.